time is 9:25 a.m. December 17, 2018. The Nevada Commission of Judicial Discipline is now back in session. Taking a brief recess. Mr. Pitaro.
If I may, during the questioning of the last witness, there came an issue of the effective date of the contract. Her testimony was the contract wasn't in effect and she did not have to, and she didn't do the written notification to Marisa Proctor. We went in during the break and we checked, and the contract was in effect. That is the current thing, and that contract has been in effect since July 1st of 2017. So it covers the period that we were talking about. And based upon that, then we've resolved the problem to the satisfaction of the state.
I'm not sure I agree with the characterization of Ms. Coach's testimony, but based on the warranty just provided by counsel, he said that the copy of the page of the union agreement that he has moved for admission was in existence in 2017 with that representation. I will not object to its admission, and I also do not object to the admission of any of the other exhibits proposed by respondents. And it's my understanding that respondents have no objection to the admission of the prosecuting officers exhibits 1, 2, and 3, which were date stamped consecutively from 1 through 1,167. Is that correct, counsel?
No, we have to transfers. It's included.
We can read our record in reference to any documents that, 1, have no foundation, or 2, are hearsay. The chair's recommended, so we yield to the chair's directive. Other than that, we preserve the issue for, if necessary, with our objection.
And one of the things that the union contract, the reason we put that one page in and 2 pages, that's in I didn't think we all needed another basically 92-page contract with the one section of it. That's why we only did that portion of it.
Those various exhibits will be admitted, and I think we kind of made a record previously that the commission view is that all the documents relied on by the commission in doing their notice of intent to proceed with an interim suspension are within the record in terms of what was considered by the commission in writing at that determination. I understand Mr. Terry's concern, but this is we're still in the investigative stage of the proceeding, and those are the materials that were relied on by the commission in writing at that preliminary determination, and so they're within the record. So those exhibits, Mr. Bradley, will be admitted at this time. Anything else to address?
Your Honor, during the break, we decided that since we still have 1 hour and 31 minutes, we would like to take Mr. Terry's up on his offer to allow the judges to be called during the prosecution's case in chief. So at this time, I call Judge Tobiasson.
Okay, Judge Tobiasson. If you would. Please face me, raise your right hand to be sworn. Do you solemnly swear in the testimony provided in this matter is the truth, the whole truth, and nothing but the truth, so help you God? Go ahead and have a seat there. Just go up close to the microphone there, state your name, spell your first and last name for the record.
Melanie Andress-Tobiasson, M-E-L-A-N-I-E, Andress, A-N-D-R-E-S-S, T-O-B-I-A-S-S-O-N.
Thank you. Go ahead, Mr. Pratt.
Judge, are you familiar with the Nevada Judicial Code?
Yes.
And can you tell us the difference between the judicial canons and the judicial rules?
I'm not sure I can define those distinctly separately. I mean, the canons clearly are directives or rules that we must follow in terms of our ethical obligations and guidelines. Rules are simply rules that we must follow in the course of conducting our business as judges.
How many canons are there?
Unfortunately, I don't know the exact number.
And I'm going to object relevancy. What has this got to do with this? I mean, how many commandments are there? How many amendments are there? Constitution.
The judges are denying that they did not violate the code. I want to explore whether or not they know what the code is.
Well, I don't have it memorized.
I'm going to prevent the question. Go ahead, why don't you start it into Brad.
So do you know what canon 1 provides?
Well, I mean, is there a directive that I can look at the canons? I mean, I do not have the canons memorized.
Okay, I understand that. But you don't have any idea what canon 1 says, correct?
Not from memory now.
Well, let me help you.
Okay.
Canon 1 provides in part that a judge must observe high standards of conduct, so the integrity of the judiciary must be preserved. Okay? So tell the commission how you would define integrity.
Well, integrity is a lot of things. It can include truthfulness, conducting yourself in a way that is in a manner that is honest and honorable and truthful.
And how would you define impropriety?
Well, there's a multitude of ways you can define impropriety.
How does the code define impropriety?
I'm not sure what the exact definition of the code is. I mean, if you want to give me a copy of the code, I'd be happy to refer to it.
Would you agree that impropriety includes conduct that undermines a judge's integrity?
I guess on a general basis it could.
And do you know what rules apply to canon 1?
Not from memory.
Are you familiar with Rule 1.1 that says a judge shall comply with the law, including the code of judicial conduct?
Yes.
And are you familiar with Rule 1.2 that says in part, a judge shall act at all times in a manner that promotes public confidence in the integrity of the judiciary?
Yes.
And what do those rules mean to you?
Well, they're extremely broad, but a judge acting at all times in a manner that promotes confidence in the judiciary is conducting your job and your professional actions in a way that promotes public confidence and also promotes the administration of justice.
And we can agree that that public confidence is not just what happens in the courtroom, but what happens outside the courtroom, correct?
I guess in certain circumstances.
What's that?
I believe in certain circumstances, yes.
What circumstances would a judge's conduct outside the courtroom not apply? When would the code not apply?
Well, I think at some point it's forgotten that judges are actually human beings who have a life outside of their job and engage with people in ways that have nothing to do with their job or these directives.
Would you agree with the following statement that a judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code?
It's quite apparent that that's...
What's that?
I said it's quite apparent that that's the case.
And you agree with that? That's fair.
Well, under certain circumstances it's fair, under certain circumstances, I think it's not necessarily fair.
Can you cite any cases or rules or commentary that would suggest that there's any limitation to this
Well, I
statement?
think there's certain situations where, just like in any circumstance, there are judges who are looked at for everything they do, no matter what it is or what people say it is, and there are those who aren't. So I don't think it's applied across the board.
Are you suggesting that this commission is looking at you
I'm not
differently than
suggesting
other
anything
judges?
at all about this commission.
What's that?
I'm not suggesting anything at all about this commission.
Can we agree that conduct that compromises or appears to compromise the integrity of a judge undermines public confidence in the judiciary?
I'm sorry, I'm not exactly sure I know what the question was.
I'll read it again.
Thank you.
Can we agree that conduct that compromises or appears to compromise the integrity of a judge undermines public confidence in the judiciary?
Again, it's very broad. Sure, I think there are things that could. I also think that there are things that can be alleged that, if true, absolutely could.
Are you aware?
Your allegations don't necessarily mean that that in fact has happened.
So Judge, I asked if you knew the difference between canons and rules. Are you aware that the Judicial Code also has something called a commentary?
I've read the entire thing at some point, but
So what I just read you was a comment, was one of the comments to the rules, so you're not familiar with that comment?
well, you asked me if I agreed with that statement.
Right. And now I'm asking you
It's
to be
very
familiar.
general.
I'm sorry, go ahead.
No, go ahead.
So now I'm asking you, you seem to be unsure about whether that statement is
I
correct.
didn't say I was unsure. I said, of course, it could be correct under certain circumstances. I think it's very broad, and to just say that that is,
Would it be fair to say you didn't recognize it as one of the comments in the code?
well, I can assure you that I don't have the comments memorized.
So is it important, I mean, when you first got your complaint, there were a number of code sections listed, right, about what this commission thought you may have done wrong, or at least what the complainants thought you did wrong, right?
Yes.
And then you had a notice of suspension. You knew about that,
Of
right?
course I did.
And then I'm assuming you read my 3 hearing brief,
I sure did.
and I cited a bunch of rules in there, didn't I?
Yes, you did.
Okay. So what I'm talking to you about were all these things that have been in your life recently. And it doesn't appear to me, at least, wait, I'll withdraw that comment. So tell me what Canon 2 is.
Well, I'd be happy.
Can I object to the form of the question? We can relate it to what we're doing here today and what the allegations are. There are things that are in Canon 2, for example, that have nothing to do with this hearing.
I can ask whether she's familiar with the code that she says she did not violate. I want to know if she can even tell me what Canon 2 relates to. It shows an utter lack of knowing the code. The code requires that she follow the law, including the code. How can she follow the code if she doesn't even know what it is?
I'm going to permit Mr. Bradley to form the questions as he sees fit. Go ahead, Mr. Bradley.
Well, I have notebooks and boxes full of documentation over there. I can tell you that I have not memorized the code. I cannot tell you, sitting here, and define to you what the entire code says without it sitting in front of me. I could, I'd be happy to take a copy of it.
There's 4 canons, and so far you can't tell me what any of them said, correct?
Not from memory.
Well, let me see if I can help you. Canon 2 says a judge shall perform the duties of judicial office impartially, competently, and diligently. Okay?
Okay.
So and you were perhaps not formally charged, but put on notice that you violated several rules that fall within Canon 2. Can you tell me what any of those rules say?
Not
Object to the form of the motion, deleted to what we're doing here today.
So you were, one of the rules that you were, that was indicated you may have violated is Rule 2.3B. Are you familiar with that one?
I'm not by memory.
So again, let me see if I can help you. Rule 2.3B in part provides the judge shall not in the performance of judicial duties by words or conduct engage in harassment. You familiar with that rule?
I am.
And can we agree that's an important rule that should be strictly enforced by this commission?
Of course.
And are you familiar with Rule 2.5A, which provides in part that a judge shall perform administrative duties competently?
Yes.
And we can also agree that this commission should strictly enforce that rule.
I don't know, I can't impose anything on this commission. It's an important rule.
Are you familiar with 2.5B, which provides in part the judge shall cooperate with court officials in the administration of court business?
Yes.
Again, another important rule that should be enforced.
They're all important.
Now, court officials, that would include Kim Camplin, correct?
Would have.
Correct. It would have included Elizabeth Coda.
I'm not sure she's a court official, and she's an employee.
You don't know whether or not the code applies to persons who held the position of Elizabeth Coda?
She was an employee.
That wasn't my question.
If you define her as a court official, then I guess she fits under the rule.
As you sit here today, wait,
I mean, I never had a conversation with Ms. Coda.
so we can agree that a judge has to be patient, dignified, and courteous. Correct, that's Rule 2.8B, correct? Okay. Who does that apply to? Who do you have to be under the rule? As you sit there today, who do you think you have to be patient, dignified, and courteous?
I think it's important to be that way with all people.
Who are you required to be patient, dignified, and courteous to under the rules?
Well, attorneys that appear in front of you, defendants that appear in front of you, parties that appear in front of you, and people that you work with.
So now you're saying that it would apply to
I
Elizabeth?
didn't say it didn't apply to her. I only questioned her actual title in terms of court official. However, of course, it would apply to everyone.
So we can agree, Kim Campling.
It would apply to everyone.
If you can, I'll be polite, let you finish your answer. If you're polite, and let me finish my question. So it would apply to Kim Campling, correct?
It would apply to everyone.
It would apply to David Denson,
It would
correct?
apply to everyone.
It would apply to Elizabeth
It
Coda,
would apply to everyone.
Maggie Tucker,
It would apply to everyone.
and Ms. Greer, correct?
It would apply to everyone.
Would you agree with the statement that a judge must act at all times in a manner that promotes public confidence in the integrity of the judiciary?
Yes?
Let me ask you about some specific examples. Do you think a judge who arrives in the courthouse and says to the court employees, "Hey bitches, I'm here," if a judge did that, can we agree that would be in violation of the rule that a judge act in a manner that promotes public confidence in the integrity of the judiciary?
If it were true, I suppose you could make that argument.
I'm not asking you whether it's true, I'm asking you to assume that if a judge does that, you can agree that that would be a violation of the rules,
I
correct?
can't agree it would be a violation. I can agree that it could appear to be a violation.
And again, I'd like you to assume that a judge calls up a court administrator and greets her with the phrase, "What's up, mother, F-U-C-K-E-R." I'd like you to assume that happens. Can we agree that if a judge did that, that would violate the rule to act at all times in a manner that promotes public confidence in the integrity of the judiciary?
I'm not to object to that, because you're rendering an opinion that it's your obligation to render, not hers, as it applies to Judge Chelini, if in fact that is true. But asking her to give the opinion of items that are not attributed to her is not fair.
Actually, Your Honor, that is not correct, because the code requires that a judge disclose acts of misconduct by other judges. This commission in the Hahn case recently held that a judge must disclose acts of misconduct by other judges. So I'm entitled to ask her if she thinks that's an act of misconduct.
With the question, why don't you restate the question?
Sure. I'd like you to assume that a judge greets a court administrator with the phrase, "What's up, mother, F-U-C-K-E-R." If the judge in fact did so, can we agree that that judge violated acting at all times in a manner that promotes public confidence in the integrity of the judiciary?
And I would object to that question.
Lord object, let's hear the answer.
I think he was restating the question in my direction, so.
Oh, sorry.
He was restating the question, so please go ahead and answer your question.
But I don't object to that question that he's restated.
Your continuing objection is noted, Mr. Pitaro.
I don't necessarily think saying something, even if it involves language, would be a violation depending on the content in which it was stated. And I certainly wouldn't have had any personal information or personal knowledge or exposure to this.
Where do you think the use of profanity is permissible by judges at a courthouse, and where do you draw the line and say it's not permissible?
That's a loaded question, but I mean, the use of profanity is fairly common. Certainly, I don't think it is appropriate to be directed at somebody in a hostile way or to be directed at somebody in the courtroom environment. I don't know exactly where the line would be drawn.
So are you saying that it's okay for a judge to use profanity such as the F word or bitch or mother, F-U-C-K-E-R, as long as it's not in the courtroom?
No, I did not say that. I said if it were to be directed at somebody or used in a way that would be something other than just using it in the normal course of talk.
So using Mr. Terry's example, it's okay to say mother, F-U-C-K-E-R, as long as I don't say you're a mother, F-U-C-K-E-R.
Not in every circumstance, no.
Do you think that the common use, the routine use of profanity around court staff is permissible?
Common as in constant? No.
Routine, daily.
Well,
If daily you use the F word, is that appropriate or inappropriate?
under what circumstances?
You're outside talking to staff, you're not directing the F word at somebody, you're just saying, I had an effing day here, or this effing thing happened, or I'm so effing mad at something else. Isn't that completely beneath your position as a judge?
I guess it would depend on the circumstances.
So the use of profanity doesn't denigrate the office?
I guess I'm not as offended by the use of some profanity as apparently others are.
Well, let's talk about your sweater. You have a sweater that says, "Eat shit and die," correct?
Correct.
And you wore it to the courthouse more than once, correct?
No,
So,
I know it's been stated I wore it more than once.
so was it okay to wear it once?
Well, I wore it.
No. Was it beneath the dignity of your office to wear a sweater to the courthouse to be seen by court staff that says, "Eat shit and die"? Is that appropriate?
I could see how it would be viewed as inappropriate. I did not feel it was because of the way it is hidden in the shirt.
So the fact that it wasn't in,
Would I do it again?
the fact that it wasn't in bold language made it okay, but the fact that it was a little harder to see makes it fine? Is that what you're saying?
I'm saying I did not view it as denigrating the dignity.
You don't see a problem with that?
I did not.
We've heard testimony that you wore it more than once, and you in fact even bought a pair of shoes that would match it. That's not true?
That is not true.
The shoes you had did appear, at least from a male perspective, to match your sweater.
It's a sexist
I
question.
probably have shoes in every single color.
Objection to the question.
Hold on a second.
Sexist in nature.
I was denigrating myself, Mr. Terry, by saying that my color decisions aren't as good as my wife's. I withdraw it.
Okay,
Question.
thank you.
But we'll do that for you if you need it.
So, you deny you bought a pair of shoes that match the color of that
Yes, I
sweater?
do.
Okay. And where did you come up with this? Where did you buy that sweater?
That's irrelevant.
She wore an inappropriate sweater. There's an issue of,
That's a question for this commission.
I'm going to sustain it as it's relevant.
before you put her on that day and wore it to court, did you think, geez, I wonder if this is appropriate?
Not sure that I have that thought.
In evidence, I think we saw a photograph of you with the cutout of some actor whom I'm not familiar with. Do you recall seeing that in the list of exhibits? So who was the
I
actor?
don't know that that's in the exhibits, Your Honor. I believe it's in the brief.
Actually, if you could turn in the white binder to Bates number 1027.
Jason Momoa, by the way.
And,
The actor is Jason Momoa.
okay, thank you.
And it's not him, it's a cardboard cutout.
You know, I kind of thought that. And this photograph was taken in your chambers, correct?
Correct, with my friend who is dying of cancer. He was here yesterday and probably will be here today as well.
And you had your assistant take this photograph, correct?
I'm not sure who took the photograph, quite frankly.
And how long did this cutout actor spend time in your chambers?
Still there?
Still there? Did you think posing for a photograph holding the area beneath the actor's belt is judicially appropriate?
Well, actually, we were laughing. My friend had been in chemo the day before, and I kind of this makes me feel uncomfortable, is having to bring that aspect up, because I would never want to, like,
It seems like
denigrate
it seems
her.
like you're willing to bring it up, but
Well,
I'm asking about your
You're
conduct.
willing to bring up the picture, so I'm gonna explain the picture. She came to see me the day after I sat at chemo with her, and we were laughing and taking the picture because she saw the cutout. And in fact, when we were standing there, she pulled my hand, and it is cardboard. It's not actually a man's property.
And you posted this on your Facebook?
I don't know if I posted it or if she posted it and tagged me, but it is posted.
Would you be willing to allow the commission investigator access to your private Facebook post?
Apparently, they already had it.
That's not my question.
What, Mr. Wodnanski? Probably not.
If we subpoenaed that, would you fight it?
Well, I can assure you that it would find a lot of dogs and a lot of things that are charitable in nature on my Facebook page.
So you wouldn't object to us?
I can't stop you from doing that.
Who is your cell provider?
Verizon?
Do you have a duty to cooperate?
Of course. Of course.
What?
I said Verizon, I answered the question.
Couldn't hear you. Fair to say that judicial misconduct that's part of a pattern or practice is more serious than an isolated instance of misconduct?
If it's actually a pattern.
And can we agree that judicial misconduct that occurs spontaneously is less serious than misconduct that's premeditated or deliberate?
Again, I think something that happens one time that's severe could be far more serious than a pattern of perceived or portrayed to be inappropriate things.
Have you and Judge Chelini entered into a written joint defense agreement?
A written what?
Joint defense agreement?
Objection irrelevant and it intrudes upon the attorney-client relationship.
The reason I'm asking, Your Honor, is so I want to ask about who she's had conversations with. And if there's a joint defense agreement, then obviously it would include conversations that this witness has had with Mr. Pitaro. If there is no such agreement, then I think I'm entitled to ask about her conversations with people outside of Mr. Terry's office.
Well, number one, the necessity for a written agreement doesn't exist. Verbal is just as good.
I asked if there was a written joint defense agreement, and I did not get an answer.
And we object to the question because it intrudes upon the attorney-client relationship.
I'm going to sustain the objection.
Have you spoken with other persons about the commission's investigation other than Judge Chelini and the rest of your defense team?
Very few people.
And who would those few people include?
My husband,
Who else?
I couldn't tell you who. I've tried very hard to not let this consume the entirety of my life.
Have you
And I
talked?
try not to discuss it on a regular basis.
Have you
And I
talked-
don't have to.
Have you talked to Judge Baucum about it?
Not in any significant detail or, I've allowed the attorneys to handle those things.
What about the other witnesses on your list, without having to go through all of them? Have you talked to any of them about this investigation?
Very little. I've not talked to them about what their testimony will be or any of the significant areas.
Have you talked to Jose Espinosa about this?
Not about his testimony or any of the significance. Again,
How
this
about,
has created an extremely stressful.
I'm going to object to this line of question. There's nothing impermissive for her talking to any witness, be they special prosecutor witnesses or respondent witnesses.
I'm not suggesting there is. I'd get a follow-up. If you talk to somebody outside her attorney-client privilege conversations, I can ask her about the substance of those conversations.
I'll permit the question.
And again,
Did you talk to Jose Espinosa?
I've talked to Jose, but
And what
not
did-
about the content of his testimony or those things.
Did you talk to Brazil Hernandez?
Very
about this?
little. Very little.
How about any Clark County officials?
Not that I can think of.
Have you sent out any emails to any of your witnesses or any texts to any of your witnesses discussing their testimony?
I don't believe discussing the testimony.
Did you send out any texts or emails to the people on your witness list regarding the investigation?
Not, again, not in the specifics of the investigation. I mean, everybody's pretty much aware of the investigation at the courthouse. It's pretty common knowledge.
And did you have any involvement at all in the termination of Ms. Coda, Mr. Denson, or Ms. Camplin?
Absolutely none, with the exception.
And there'd be no,
With the exception of the vote that the judges took at a special judges meeting with regard to Kim Campbell.
and I just want to confirm then, there would be no emails or texts from you regarding the firing of the people I just mentioned.
Absolutely not.
You were interviewed by the commission investigator in this case, correct?
Correct.
And it's your testimony that you answered his questions truthfully, correct?
I answered his questions, the questions that were asked without having any knowledge of what the accusations were, without being provided a copy of the complaint. The only thing I could say is perhaps there were some questions I would have answered in more detail, but I at least been apprised of what the actual allegations
Judge, the
were.
question was, did you answer his questions
Yes,
truthfully?
absolutely.
That's all I asked you. All right. Now, yes or no, did you tell the investigator there's no such thing as a blacklist?
I did.
You did say that,
I
correct?
did say that.
Okay. All right. And you told the investigator that you never referred to Ms. Coda as a effing bitch, correct?
Absolutely said that.
And by effing, I mean you
I know what you
actually,
mean.
you actually used the entire word.
I actually didn't.
All right. In fact, you said you were astonished by an allegation that you would call her effing bitch, correct?
I was astonished by the allegation that I did call her that.
Now, is that because you don't usually use profanity?
That's because I never said that about her,
So
or to her, or in her presence, or outside her presence.
we can agree that you do use the F word commonly?
I don't know how you define commonly, I have used the
Routinely.
F word, I have cussed.
You
I
routinely use the F
acknowledge
word.
that in my statement.
What's that?
I acknowledge that in my statement, I cussed.
All right. And so you use the F word, you've used the word bitch, correct?
I've cussed,
Right? Is that a yes?
yes.
All right. So is it that you're denying that you use them in conjunction? You say
I
F and
didn't
you
say
say
I
T,
denied
but you
using
don't
them
say
in
F.
conjunction.
I'm sorry,
I denied saying that to Elizabeth Cook.
But you have called people an F and bitch before, correct?
Objection relevancy. What does that have to do with the scope of these proceedings? If we're talking about a court administrator, a court employee, a fellow judge, a defendant in a courtroom, a lawyer, different objection. But
Would you clear Mr.
if she goes home and has an argument with her,
You make a
I
fair
should
point
shut up
about
at
Terry.
this point.
In the
Why
courthouse.
don't you narrow the scope, Mr. Bradley?
In the courthouse, have you ever used the term F and bitch?
I don't know, I can't think of a specific time, but I can assure you I didn't use it directed at or on that day.
Okay, so when Ms. Cota got up on the stand and swore to tell the truth, she lied to this commission,
She
correct?
did.
All right.
Or she made a serious mistake, but I can assure you, I did not call her that day.
Okay. And you denied saying, "Here I am, effing bitches," when you come to work, correct?
Yeah, I don't have a recollection.
And you said, in fact, you told the investigator, "I don't recall saying that."
I did say that, I just said the same thing, I don't have a
So-
recollection of saying that.
But if you had a practice of arriving and saying, "Here I am, effing bitches," you'd be more likely to remember it.
Yeah,
Okay. So, but we can agree that a judge who announces her arrival by saying, "Here I am, effing bitches," that's offensive, isn't it?
yeah, if I did that every day, I sure think it would be offensive.
All right. And morally offensive, right?
Well, I don't know about morally offensive, but it would be offensive. Or at least would be inappropriate, I don't know.
What's your distinction you're drawing between offensive and morally offensive?
I don't know if it's immoral.
Not immoral to,
There's a distinction. I mean, some people think some things are immoral that other people don't.
do you think it's morally offensive to say, "I'm here, effing bitches"?
To some people it may be, but
To you?
I don't think it would morally offend me if somebody said that.
But you just can't recall whether you said it.
I don't have a recollection of saying that. Initially, she said that she heard, somebody told her that I said that, and then on the stand, she said that she personally heard it, so.
So, in your interview with the investigator, you denied telling Ms. Campling that your husband is ex-Metro, that you know detectives, and you have friends with the FBI, correct?
That conversation never happened.
It is true your husband's ex-Metro.
Sure is.
It's true that you know detectives.
Of course I do, I'm a
And
judge.
it's true you are friends with the FBI.
No, it's not actually. I knew one FBI agent, but I'm no longer allowed to speak to him.
So, I think you're also denying that you strike sign. In the interview, you said that I have never threatened somebody with my husband or the people I know, correct?
Correct.
And you said that's offensive.
Correct. To be accused of that
And you
is
told the
incredibly
investigator
offensive.
the allegations that you threatened people is completely out of the realm of comprehension. Do you recall that?
Yes, I do.
Because I would never engage in that kind of behavior. That's what you told him, correct?
Correct.
But that's not true, is it? In fact, you have bragged about threatening people, haven't you?
No.
Did you give an interview to the Baltimore Post-Examiner in 2018?
Objection, relevancy.
I'm laying the foundation for the threat.
Nothing to do with these proceedings, Mr. Chairman.
She denies she ever threatened someone. She admits that she threatened someone in a newspaper article, and there's an audio recording of it.
I'm going to permit the question. Go ahead.
Did you give an interview to the Baltimore Post-Examiner in 2018?
Very unfortunately, yes.
And they recorded the interview, correct?
It was a recording of a conversation. It was never intended to be published.
Now, I am mindful of the prior objections of your attorney, so I'm not asking you to give me any background about why you were upset with a certain individual, and we'll just use his initials, SD, okay?
And I wanted to have continuing objection to this whole line of questioning as being irrelevant and not in conjunction with the proceedings that we are here on. The allegation is very specific. Poses a substantial threat of serious harm to the public or the administration of justice. Based upon that, it is irrelevant.
Kim Campling said that she was threatened by Judge Tobiasson. Judge Tobiasson said that she's never threatened anybody. I have the right to impeach her statement based on her own words. It's completely relevant to this case.
I don't recall Ms. Kaplan being asked that question, merely because it's in the interview doesn't speak to its truthfulness. If the special prosecutor purposefully did not ask a question, but is going to continue to rely on the transcripts, that only re-echoes the reason why we've objected to the utilization of the transcripts.
There was testimony here about the fact that she felt threatened. She
Felt threatened and being threatened are two different things. I feel threatened in these proceedings because of what is going on in reference to my client. That doesn't mean that anyone has a personal vendetta against me.
The impeachment question is perfectly relevant. I'll commend it.
Did you tell the Baltimore Post-Examiner that you were trying to prevent an individual from contacting a member of your family? So you called his attorney and said, quote, "Hey, you might want to get your client a message that if he calls my family member again, I'm going to take care of it myself."
I know that's what I said, and I also know that I was in a position where I had begged for help and gotten none. Not only have I not gotten help, but I later learned.
So you admit,
I
to
didn't
make the
threaten
statement. I'm not
the
asking you
person
what, I'm not
directly.
asking you
Hold on
why.
a second. Please don't speak over each other.
I did not threaten a person directly.
You threatened through his
This
attorney.
person was continuing to contact a member of my family on a day that
Excuse me, if you're going to open the door to a bunch of questions about why this happened, then I get a follow-up. So I would suggest that you answer my question, which is, did you make that threat, yes or no?
it wasn't a threat.
Okay. Do you know who Christine Contreras is?
I do.
Is she Judge Goodman's clerk?
I believe she is.
And did you tell Ms. Contreras that this commission will look into every nitty-gritty detail?
I don't believe those words I used, but unfortunately, that conversation was misconstrued as well, which is why I don't talk to anybody about this investigation at all,
So
even though they continue
So
to.
you did have a conversation with
I
Ms.
did.
Contreras?
I
Yes?
never denied that I did.
And you did talk about the commission's investigation with her, correct?
We did discuss the investigation.
Okay. And she wasn't one of the people you listed earlier as somebody that you spoke with regarding the
I
investigation?
didn't even think about it.
Okay. And you told Ms. Contreras that once that door is open, they, the commission, there's no going back, they look into everything, right?
Well, I don't know that I used those exact words. In fact, there were many things that she stated that were misrepresented in our conversation. It was a short conversation, and there were quite a few things in her statement that were not accurate.
So she's also providing false information to
The
this
statement that she gave was not accurate. It was not an accurate representation of the things that were said in that conversation.
Okay, so if I'm keeping track right, Ms. Campling, Mr. Denson, Ms. Coda, Ms. Tucker, Ms. Breer, they're all aligned with this commission, correct?
Unfortunately, yes.
And you are an innocent victim of all these salacious lies, correct?
It would appear to be that way.
Those are all the questions I have. Thank you.
Okay, why don't you give me the statute? I'm not putting up with any of the crap here today.
Don't unpack. That's not what the Jay's hearing's for.
The likely result of that is you will be remanded into custody.
Counsel, your appearances for the record.
The court has a few comments before we begin.
We are on the record in the matter, case D-505.
You guys either agree or I order.
Mr. Terry, recognized.
You're a judge,
Yes,
you have a First Amendment right,
sure do. Well, I used to before I was a judge.
right to free speech. You're entitled to an opinion,
Yes,
you exercise that opinion.
yes.
Are there occasions when people misconstrue you're making requests or making demands?
Absolutely.
As an example, your request to keep Jose in your courtroom to run an efficient court, someone could have looked at that as being harassment.
I don't know how they possibly could have, but they did, or they said they did.
Sort of like you, isn't it, Your Honor? It's in the eye of the beholder. Correct?
Right.
So it's easy for someone to come in here and go, I felt harassed, merely because you questioned something that was being done, correct?
Right.
One of the issues that has come up through the course of this hearing is your relationship with Rita, the clerk.
Yes.
You gave her $5,000.
Right.
Why did you do that?
Because she was in a very dire situation, and I had the ability to do it. I also did it because she's been in a situation for close to 7 years where she's not permitted to work in my courtroom, at least not on a permanent basis. And there's no possibility of us having that sort of a relationship with
As a
the
matter of fact, you were the one that said she shouldn't be in your courtroom, correct?
I was the one who reported the behavior that I had learned back in 2013 to the court administrator, which resulted in her being removed from the courtroom and not permitted to return to the courtroom for a period of years. But the understanding was that she would never be able to be returned to my courtroom, and that was the understanding of all of the court administrators and supervisors.
And that was one of the reasons why we objected to the movement of Jose, because they were putting Rita back in your court.
Correct, it's one
And
of the
you
reasons.
told-
Go ahead, I'm sorry.
And you told the individuals that, correct?
Yes, it's one of the reasons I questioned why, the reason that they gave me for his movement and the purpose of putting Rita back in my courtroom, because they all were aware that she was not permitted to be in my courtroom, not because of a blacklist, but because of an issue where I had actually had to report her behavior to her supervisors and her bosses. It was a very painful thing for me to have to do, but I had to do it despite the fact that we worked well together, I liked her, and we had known each other for years.
And in reference to that situation with Jose, you in fact met with individuals and told them specifically that was one of your reasons, in addition to the fact that Jose was a good backup clerk for
I
you.
did. I discussed it specifically with Will Jimenez.
Now, counsel brought up the quote blacklist, but there's been testimony that there are occasions when, such as the Rita example, it would not be uncommon for you to indicate that you would prefer that that clerk not be in your courtroom.
Correct.
Okay. What is your function as a judge as far as running a courtroom?
My function as a judge is to try to run an efficient courtroom, to effectively and appropriately administer, we say administer justice, but the reality is you have an enormous caseload, and your responsibilities and requirements are to try to run that caseload as efficiently as possible, but also without cutting corners in terms of hearing people, giving them an opportunity, evaluating each case on an independent and objective basis, an impartial basis. It's not always easy because people portray things in a certain way, and you have to take the time to do that, but you also have to do it in a way that moves things along. We have an enormous caseload. And in the 20 years that I have been doing this job, as on a part-time basis or a full-time basis, there has never been a situation where I have been accused of doing it otherwise, or not been complimented for doing it as well as or better than the other judges who do the job that I do.
No further questions are cross-examination.
I assume Mr. Pitaro, you have a question?
One moment. I have no questions.
Redirect.
No redirect.
Can we update the parties as to their time?
Prosecuting officers have 45 minutes remaining. Respondents have 2 hours and 5 minutes.
Okay. Do you have any further witnesses? Prosecuting officer.
Given my, excuse me, Your Honor, given the fact that I have 45 minutes, prosecution will rest.
Okay. Before we move on to respondent's case in chief, do you need a break to regroup?
Only I would like to tell the witnesses that we've been delayed. If that's
Okay.
all right.
Let's just take a very brief break and then reconvene. Get situated here, we'll get started. Okay, back on the record. Time was 10:33 a.m. December 17, 2019. We've taken a brief recess. I believe it's now respondent's case in chief. First witness.
Amy Chelini.
I'm
I'm
going to
going to
review.
go get the first witness, but I think I can find Judge Chili.
We'll wait for 1 moment for her to get back.
Very quick. Judge?
Record reflect that she is now back in the room.
Thank you, Mr. Terry.
Okay, Judge Baucum, would you come up here to stand, please?
Our first witness would be Judge Suzan Baucum.
Please face me, raise your right hand and be sworn. Do you solemnly swear any testimony you provide this matter is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Please scoot up closer to the microphone there, state your name, spell your first and last name for the record, please.
Suzan Baucum, S-U-Z-A-N. Last name Baucum, U as in boy, A-U-C-U-M as in boy.
Go ahead, Mr. Terry.
I've referred to you already as Judge Baucum. You are in fact the judge of the Justice Court.
Yes,
You are the chief judge of the Justice Court.
that's correct, since January of this year.
Would you give the commission an idea of your professional background, please?
After graduating law school, I did an internship with the Ada County Prosecutor's Office in Boise, Idaho, and practiced with a law firm in Reno, Nevada. From there, I was a state trainer specialist and staff attorney for the National Council of Juvenile and Family Court Judges, where I did training programs for judges, attorneys, and social workers across the country, dealing with the Adoption Assistance and Child Welfare Act. I set up 15 model court programs across the country, so kids would be taken through the court system according to the Adoption Assistance and Child Welfare Act. While I was doing that, I was approached by Justice Rose to throw my hat into the ring to apply for the Nevada Law Foundation Executive Director position. I applied for that position and worked for the Nevada Law Foundation for 1991 until I retired from there in 2009. While I was doing that, I also sat as a pro tem judge in Las Vegas Justice Court, Henderson Justice Court, Las Vegas Municipal Court, and sat as a hearing referee in the 8th Judicial District Court Family Division. I ran for Las Vegas Justice Court Department 13 in 2010. I was elected and I took the bench in January of 2001.
So you've been on the bench since 2011?
Correct.
All in the Justice Court for Clark County, Nevada?
Yes.
All as a justice of the peace?
Yes.
To a certain degree, based upon the time elements that we're facing, I'm going to lead you through a couple of things. First of all, there's been mention throughout the proceedings of a blacklist that existed in reference to clerks. Are you familiar with that?
I never knew a blacklist existed until the investigator asked me that question.
That's exactly what I was going to ask you. Did you know the blacklist that existed?
I did not know that there was a blacklist.
Were there, however, occasions when a judge would indicate that they preferred certain clerks to not be in the report or certain clerks to be in the report?
Well, I know that Judge Lippis formerly didn't like to have certain clerks in her department.
And as a result, Judge Bonaventure issued a memorandum which basically the commission has heard already that indicated basically keep the clerks where they're at. If there's going to be any changes, let us know.
apparently, where it was also discussed. I was on call during that judges meeting, and I had left the judges meeting a couple of different times during the discussion of that particular issue.
You believe you have a right to indicate to the administration a preference or a dispreference to certain clerks?
I do.
Why is that?
I think it's very important for the administration of justice, for clerks and judges in a courtroom, for judges to have a say. You don't put a slow clerk with a judge that's faster. You don't put, in my opinion, a baby clerk or a brand new clerk with a brand new judge. You need to have some with experience. I think administration needs to understand not only their judges, but they also need to have a good idea of who the clerks are, their strengths and weaknesses, because it's very important that judges and clerks are equally matched. For example, I have a new backup clerk in right now who's been in training for the last several months. It's been very difficult because she's slow and she's not familiar with the attorneys, not familiar with all the processes. So we've had, my regular backup clerk has been sitting behind her training, and that's fine because she's there and she can help out. But the minute she's not there with her, the clerk has difficulties handling the counter, because I have, some days I have 150 or 200 cases on, and it's a very fast-paced moving courtroom. And so
run the DUI course in addition to being the chief judge.
That's correct. So it's very difficult. So last week on Mondays are Tuesdays are the biggest days that I have. The clerk was having difficulties. The line of attorneys was almost all the way out the door, and she wasn't able to pull the cases fast enough. So I said to my lead clerk who sits next to me, hand me half the cases. So she just handed me half the cases. So I was pulling cases as attorneys were walking through the door, and I just set them off to the right. So to try to facilitate and keep the flow of the courtroom. Because as you know, Mr. Terry and Mr. Pitaro, Mr. Sully, you guys have 17 floors of courtrooms in the Regional Justice Center that you have to be at any given time between 7:30 and 9:30 or 10 o'clock in the morning. So it's important to get you guys in and out. And if you have a good, strong clerk that can help facilitate that, that is important. It helps the court run more efficiently. And I absolutely think that as a judge, we should have say as to who the courtroom clerks are for the administration of justice.
Your priority is to run an efficient courtroom, correct?
Absolutely.
And if that courtroom is not efficient, it comes right back to you, doesn't it?
It absolutely does. And we get nasty comments in the review journal poll that we're not efficient or we're not managing our calendar to the best of our ability.
You became the chief judge when?
In January of this year. I was elected last fall, sometime in an election on our bench.
Reminding you that the commission has already heard several witnesses here in here.
Okay.
You made certain terminations.
I did.
Correct. Were you aware at the time of the terminations that the commission was investigating Judge Chelini and Judge Tobiasson?
Absolutely not.
Was your decision to terminate any of the individuals that you did terminate based on any influence by either Judge Tobiasson or Judge Chelini?
Absolutely not.
These were unilateral decisions, with one exception,
That's correct.
made by you, correct? And we assume that these decisions were made in an attempt to run a more efficient court system.
Absolutely.
They were not made for any type of a vendetta or get even or anything like that type of situation.
No, they were not.
That, in fact, is not your purpose.
No, my purpose is to run an efficient court. You know, we had, Judge Zimmerman was a strong chief judge when I first came on the bench. Judge Bennett was a very strong chief judge. And then Judge Bonventure, who served as chief judge for 4 years, is a great guy, but he wasn't a strong chief judge. He couldn't make a decision. And so the administration of justice, in my opinion, kind of went downhill. So I came in, I had to make some hard decisions, and I made a lot of hard decisions. I don't like getting rid of people. I didn't like terminating people, but I did it for the efficiency of the administration of justice. We are tasked to provide access to justice for all of our community. And in doing that, we need to have strong people in leadership roles who are doing their jobs, who know how to administrate, who know how to supervise, who know how to take a case from point A all the way through to the closeout of the case. We need to have strong people throughout the board that know their job and will work, and are willing to work hard to do their job.
And you were not aware of the investigation that was going on by the commission. What were you doing during that period of time that would cause you not to be aware of the investigation? And I'm talking about the period of time of the terminations.
Well, the first termination that happened was in March, and that was of Kim Campling.
We'll get to this, Kim.
Okay. And then the second termination I did was of David Dote, who was a hearing traffic referee, and that was in April, Steve Pham, and then Dave Jensen and Elizabeth Cota. So are you talking about Dave Jensen and Elizabeth Cota?
Correct. We're going to start with Mr. Jensen.
Okay, so my youngest daughter graduated from high school in May. She was valedictorian. When she started, I'm just going to give you a little background. When she started her freshman year, she said, "Mom, if I'm valedictorian, will you take me to Europe?" I said, "Absolutely." Okay. So she worked her butt off. So she asked me to take her to Europe. So I did. We left June 13th. We got back into the United States on July 2nd. I had messages from my secretary that there were some checks I needed to sign as chief judge. There were some calls I needed to return. I came in, I was still technically on vacation July 3rd. I came in on July 3rd. I had a conversation with Melanie Long. I found out that my directives had not been taken care of while I was gone, and I terminated 2 individuals on July 3rd.
What was your conversation with Ms. Long?
I asked Melanie Long if, because I knew she was going out on FMLA. I said, "Are you going out on FMLA?" She said, "On Monday," and I said, "Were Dave Jensen and Elizabeth Cota terminated per my directive to Grizel and you?" "No, they were not." "Why not?" Grizel wanted to give them a chance.
In fact, Grizel, who are you referring to?
Grizel Hernandez was appointed, not appointed, she was placed in the active court administrator position after Kim Campling was terminated.
What were your reasons for terminating Ms. Cota?
Ms. Cota had been directed to do several different tasks for the court. And again, it's my honest opinion that these are Clark County HR matters and that they have nothing to do with the reason that we are here for either Judge Chelini or Judge Tobiasson. I don't think that their terminations or any of those court hirings or firings have anything to do with this. However, that being said, I will answer to the best of my ability. Elizabeth Cota had been tasked with doing several different things. She had been moved by Kim Campling from the criminal division to the traffic division because she has a lot of difficulty working with people. She's very condescending. You have a conversation with her, one-on-one conversation. If she doesn't like what you have to say, she rolls her eyes. So she is very difficult, not in a good place to be working with judges. She was moved to the traffic division by Kim Campling, so she really didn't have to have any direct report with judges. We were in a legislative year, as I'm sure all of you know. There were several traffic matters that were coming along the pike. She had been asked to do some work on the fiscal impacts of some of the traffic bills. She didn't do it because she didn't think that we needed to have, that it was a fiscal impact. Well, it wasn't her decision as to whether or not she thought there was any fiscal impact. I wanted to know whether or not there could be a fiscal impact to the court, and so she was directed to, work on some of that. She did not do it. So Sherry Paris, who currently works for the court, and she is now back over the traffic, division as the traffic administrator. She was over the community court, which she still is, court education. We had to bring Sherry Harris in to work with Grizel Hernandez, Brandy Rangel, our court finance person, to put together and analyze what these traffic bills and the potential fiscal impacts could be, because you never know if a traffic bill might be coming down the pike, but it might be the very next day that it goes before the committees for hearing, and we had to have that information. So Sherry Harris came over and helped us put those things together. And that's just one of many instances.
Do you remember Ms. Cota lying to you?
I don't ever feel that she was ever quite honest. I think she had her own agenda.
Define her own agenda.
Ms. Cota, she would go to work, but she didn't supervise. She didn't know how to supervise any of her supervisors. If there was a meeting, Ms. Cota would have Juliet come with her. Juliet was the supervisor. Ms. Cota couldn't answer any questions regarding the traffic division. She had to always defer to Juliet. So if you can't, in my opinion, if your supervisor is doing your job, your supervisor should have your job.
Do you find her to be antagonistic toward the judges?
Yes.
In what way?
She wasn't helpful to the judges. I felt like she was condescending to the judges. She wanted things to be done her way. She didn't want any input from the judges.
Can you be further on this code?
Not unless you have a specific question.
Very specific question. Let's go out down to David Debs. What was his position when you took over as chief judge?
When I took over as chief judge, he was the division administrator over the criminal division.
Now that's a position of large authority, is it not?
Yes, it
The
is.
fact that it supervises the full criminal division?
Well, the criminal division was kind of split up a little bit. Courtroom services, the clerks, and then pretrial services is a little bit different. So there are some different areas in the criminal division. But yes, he was over the criminal division for all intents and purposes.
You ultimately terminated him.
I did.
And as with Ms. Cota, neither Judge Tobiasson nor Judge Chelini had any input in reference to that termination, correct?
They did not.
What were your reasons for terminating him?
Dave Denson was not very happy when Grizel Hernandez was placed in the interim role as court administrator. And she was placed in that role. I'm just deviating a little bit, Mr. Terry. If you don't want me to, I will stop. When the decision was made by the judges as a whole to terminate Ms. Campling, I had also staffed with county management, Jeff Wells, Yolanda King, Sandy Gentat, all of the people over the county, and their opinion, who would be the best person to go into the interim position as court administrator. They all agreed that that would be Grizel Hernandez because she had the most experience in the administration role. In fact, Jeff Wells mentioned to me on more than one occasion that while David Denson was serving as the acting court administrator while Kim was out on FMLA, that he didn't ever call Dave to ask Dave any questions. He called Grizel because Grizel had the most institutional knowledge. So Dave did not want to work under Grizel. He was very dismissive of her. She, at my direction, had tasked him to co-administrate with the pretrial services division. Anna Vasquez, who's been over that division for many, many years, who's a 39-year employee, has been threatening to retire for years. She actually just gave her notice to retire here a few weeks ago. Anna, when I took over as chief judge, I asked her to promise me that she would stay with me through the year to make sure that IA court got up and running and that we could do some co-administrating with pretrial services and our criminal division in order to get somebody kind of lined up to in a succession type of plan. Dave did not want to do that. He absolutely refused. He then directed Will Jimenez, his supervisor, to go over and learn pretrial services division. And in fact, Dave, like Elizabeth, Dave could never answer a question. If you needed to know something, you didn't ask Dave because he didn't have an answer, so you went to Will Jimenez. And again, if the supervisor is the one that knows everything and is actually running your division, that supervisor should be in your division. But that wasn't the ultimate reason why I wanted to terminate Dave Denson. He's a 25-year military veteran, and he's a nice person. You know, I got along with him fine. But if you have a superior officer in the military, you do as you're told. But he didn't want to do anything that Grizel Hernandez asked him to do at my direction because he felt that she was not his equal or his superior, but that she was beneath him. So again, he was...
a situation where he called her ignorant?
He did. So on June 6th, in a meeting with Grizel Hernandez, and Melody Long was in that meeting as well, Grizel had directed Dave to do some certain tasks, and if you call her as a witness, which I think she's on your list, she can more fully explain that. After this meeting, Dave called her ignorant to her face. I said, you need to terminate him, and I want you to terminate him now. She said, well, let me try to work with them. And I said, you shouldn't be calling anybody ignorant at all. It's just absolutely not acceptable. So I went out on vacation. I came back after being gone for 3 weeks. He was still in the position. Things had been continuing to decline. I sent an email to Melody Long to terminate both he and Elizabeth Coda because neither one of them were doing their jobs as had been directed by me or by the acting court administrator, Grizel Hernandez. They were not doing their jobs as they were directed. So if you're not going to do your job, and you're not going to work, and you're not going to be accountable, you should not be working for the Department of Justice.
And once again, when was he terminated ultimately?
It was the day that I came into work. I got back from Europe on July 2nd. I came into work on July 3rd. So on July 3rd, I terminated both he and Elizabeth Coda. I sent the email to Melody Long. She actually staffed it for me.
You made mention of another individual that had been terminated in March, correct?
Correct.
And who was that?
David Doak, the traffic referee, or he handled all of the traffic cases.
Okay. We will not inquire into that other than to ask you if Judge Chelini or Judge Tobiasson had any input into that decision.
They did not.
Who else was terminated?
Steve Pham, our IT director.
And was that your decision?
That was my decision. He
You
wasn't
justified
working
in doing
either.
that?
I'm sorry, Mr.
You
Terry.
felt you were justified in doing that?
He's absolutely justified in doing that. He wasn't doing what as he was directed by the court. He had one excuse after another. And we have a strong IT director, division administrator, and now, just an example. In our pretrial services division, we have a scanner that defendants can come in and check in. They put their hand on the scanner, it checks them in, they can call in, and we were down one, and another one was going there as well. Very simple. Order one. Order a new one to replace the ones that are not working. We had it in the budget. He wouldn't do it. He said, well, we can't get it. We heard this going on not only when Judge Bonaventure was chief, but into the first couple of months. Do as you're directed, or go and work somewhere else. Do your job. He wasn't doing his job. He couldn't communicate. So the new person that came in, Tony, who got her from the county, she ordered it, and we had it within about 30 days. So it wasn't a difficult process or procedure. It's just do as you're directed. Do your job. But Mr. Terry, but again, Judges Chelini and Tobiasson, they were in the meeting or had input into the termination after the OOD complaint of Kim Kimling. That was a vote of the entire bench. But neither one of them had any input into the terminations of Steve Pham, David Doak, Elizabeth Coda, or Dave Denson. Those were my decisions as chief judge.
Let's talk about Ms. Camplin. The commission has already received a copy of the memorandum from the Office of Diversity. So that would assume that there was some form of an investigation done on Ms. Camplin, correct?
Correct.
You happen to know how long that investigation went on?
I really don't. I know the investigation was sometime in 2018. It started under Judge Bonaventure.
Do you know if Ms. Camplin was interviewed in reference to the Office of Diversity?
She absolutely was interviewed.
Do you know how often and what the content of those interviews?
I do.
How often was she interviewed?
Well, she'd been interviewed a couple of different times over some different incidents. The majority of what was wrapped into this summary closeout and all that, I believe you have at the Charter Commission.
We'd advise you that that is an exhibit before the commission. Now, ultimately, it was brought to your attention in reference to the diversity investigation, correct?
Correct.
Unlike the other four terminations, this one did involve all of the judges, correct?
It did.
Would you tell the commission how that occurred and why you felt it necessary to involve the other judges?
I received a call from Jeff Wells and I believe it was Sandy Gintet from the Clark County Office of Diversity, Clark County Management, to come over and have a conversation with them. When I got there, I was advised of this investigation into Kim Campling. There were several allegations that she had referred to Judge Bennett as a effing black bitch, as a bitch on more than one occasion, that she had ordered her staff to move her from one residence to another. That included Brandy Rangel from finance was ordered to move Kim at Kim's request. There was another incident where the same moving, where Kim Campling moved out of this residence with the help at her direction of supporting staff, and there were a couple of dogs left in the home, and Melanie Long had to go over there and understand Kim's direction and take those dogs and have them put down. But there were also allegations that Kim explicitly discussed her sexual life with subordinate staff, including Dave Denson, Elizabeth Coda, and Elizabeth Coda had said on more than one occasion that she lived vicariously through Kim's dating and sexual activities. Kim Campling also texted a photo of some man that she had been dating, nude, full frontal. It's, and I'm going to just tell you, in the courthouse it's referred to as the dick pic. And she shared that with staff, and it was totally inappropriate. And so a complaint was filed, and many of these allegations were upheld. When they talked to me about it, I was horrified. They asked me how I wanted to proceed. I told HR that I would not make a decision on anything until I had a meeting with the judges. I called an emergency meeting with the judges. The majority of the judges were there. I had a telephone conversation with a couple of the other judges who were not in the meeting. This issue was discussed. I had a memo, but it was the memo that you have, but it was down in chambers. They wanted to come down and review it. The majority of them did. And I believe it was Judge Zaragoza that called for a vote to terminate Kim Campling.
I noticed from the report it recommended a 5-day suspension, and yet the judges voted to terminate her, correct?
So my understanding, and I had asked that question at County HR, is why were they only recommending a 5-day suspension? And when they have these Office of Diversity complaints, the complaints are filed, they're investigated, and then it goes to a committee, and a committee will make a recommendation as to what they believe termination, suspension, or what the outcome should be. And in this particular one, I was advised that there was a recommendation anywhere from a 5-day suspension to a termination, and they couldn't come to an agreement. So therefore, they recommended the least restrictive method of discipline, which is what they do in all of them, and it was a 5-day suspension. But the judges as a whole did not believe that her egregious conduct warranted a 5-day suspension, that her egregious conduct with subordinate staff was for termination, and that's what the vote came down to.
And as a result, the totality of the Justice Court JPs recommended to termination.
That's correct.
And that was her vote.
That's correct.
Now, Ms. Hernandez was placed in her position, correct?
Absolutely.
And you took certain criticism for that.
I have.
Okay. Do you feel that putting Ms. Hernandez into the position of Ms. Kathleen was justified?
I absolutely do.
And how's it worked out?
It's worked out amazing. Grizel Hernandez, when I first came to the Las Vegas Justice Court, she was the assistant to the former court administrator, Ladina Gamble, and she served under Ladina Gamble for 5 years. Ladina Gamble trained her in every aspect of court administration. So when I was speaking with Jeff Wells and that group as to who would be best served to place in that role, they recommended, Clark County HR recommended Grizel Hernandez, because they felt that she was the most qualified because of her years that she had served under Ladina, Jeff Wells, and HR. If anybody else was in the acting, including Dave Denson was in the acting role while Ms. Campion was out on FMLA. Like I said earlier, they didn't call Dave Denson if they had any questions. They went straight to Grizel Hernandez. And Jeff Wells indicated that if, in their opinion, that if Grizel Hernandez was not placed in the acting role, then Jeff Wells would come over and serve as our acting court administrator and do his assistant county manager position, as well as the acting court division, court administrator during the time until whatever time we decided to do a search, for either a new court administrator or do a formal appointment of Ms. Hernandez.
Very well. There's been testimony in these proceedings that Judge Tobiasson gave a clerk $5,000. Are you familiar with that?
The first I heard about it was when the investigator, Mr. Wisnowski, or however you say his name, brought it to my attention. I had never heard that prior to.
So, when he brought it to your attention, he also asked you if you thought that was appropriate, correct?
I did.
You recall what your response was? If you don't, what is your opinion as to the appropriateness of the judge giving the clerk $5,000?
I don't remember exactly what I said to the investigator, but, Judge Tobiasson, is in a different financial bracket than most of the rest of the judges. She is the first person to help, a dog that needs care on Facebook or some other child in the community that, wants some GoFundMe page. She is always the first to step up and help out. So would it be unusual for Judge Tobiasson to help somebody in a time of need? Absolutely not. Do I have $5,000 to give a clerk if they need money? No, I don't. But I'm not in the same tax bracket as Judge Tobiasson is.
There's also testimony that the same clerk was accused of soliciting funds or obtaining funds from lawyers, and Judge Tobiasson found out about that. The question on that, correct?
I was, and that was the first I had ever heard about that as well. And I don't recall again my response, but if a clerk was taking money from an attorney that appears before that court, I absolutely think that that would be improper. But I don't know anything of the circumstances I didn't know, I had absolutely no idea as to what the circumstances were regarding that.
Were you advised that Judge Tobiasson had indicated at that point in time, when she found out about it, that that clerk should not be in her post?
I heard about that later.
As a result of the investigation, as a matter of fact.
As a result of the investigation, my understanding is Judge Tobiasson asked that that clerk be removed and shouldn't be handling any funds or any courtroom situation. And then that clerk was later, did a lot of back of house duties, not in the courtroom.
Now, at a later point in time, the commission has heard evidence that Judge Tobiasson's own clerk, by the name of Jose, she was advised on the day that he was being moved out of her department, that he was being moved, and that Rita, the clerk that she had reported for hearing that funds were being taken, were being put in her department, and she entered an objection to that. Do you recall that?
I don't recall having heard that at the time. I have since heard about that.
As a result of the investigation.
As a result of the investigation.
So let's take it one step at a time. You're running your courtroom with an efficient clerk, and you're advised on the same day that you're about to go into the courtroom, in fact, on your way to work, that that clerk is being removed. Do you think you have justifiable grounds to at least question that?
I do, and depending on who the supervisor is or who's making the decisions, I believe that most of them try to staff it with the judges to say, look, we have a problem, you know, they usually say, can we borrow your clerk to do training in another department? Yes, absolutely, but if somebody came to me and said that they were taking away my lead clerk and they're putting somebody in that position that I had removed from there many years ago, I believe that's problematic. And I believe that Judge Tobiasson, if she did ask that that not happen, that she was absolutely justified in having a discussion about that.
Judge Tobiasson says when she forms an opinion, she echoes with that opinion. She's not hesitant to echo that opinion, correct?
I'm sorry, I couldn't hear Counsel.
She's not hesitant to echo that opinion, correct?
Correct.
And the response was yes. Okay. Some could construe her objection as a demand that Jose be in the court, correct?
I suppose that could be some people's perception.
There's been testimony regarding Judge Tobiasson's attire. Now, I recognize you do not see Judge Tobiasson on a daily basis, correct?
That's correct, but I do see her a couple of times a week.
What is your opinion of her attire?
I've never seen Judge Tobiasson inappropriately attired. In fact, she has the nicest clothes out of any of the judges on the bench. And some judges would say that the three best dressed judges in the RJC are Judge Tobiasson, me, and Judge Letitia in that order.
You were asked about a sweater that...
I was asked about a sweater, but I never saw the sweater.
Were you shown a picture of the sweater?
I was not.
Okay. Were you told what was on the sweater?
I was.
Okay. Do you find that in and of itself offensive, assuming it's not worn on the bench without a robe?
Well, having not seen it and having not seen any pictures of it, but no, I don't find it offensive because, you know, the way I look at it, again, it's somebody's perception. So my understanding is there's cupcakes on the sweater and it says eat whatever and die. Well, I look at that, I think it's kind of hilarious actually. Every time you turn around, the Surgeon General or some other study has just been done on eating and what you eat. So if you eat too much meat, you're going to die. If you smoke too many cigarettes, you're going to die. Well, if you've got cupcakes on a sweater and it's saying eat garbage and die, maybe that's just referring to the fact that if you consume too much sugar, it's going to kill you. I don't know. I don't find it offensive.
That was indulgence.
No problem.
colleagues have asked me to ask a question of you in reference to the dog situation that you brought up.
Okay.
When someone had to go over to capture.
Objection relevance, we've already heard this testimony.
Well, it's part of the debate. I don't believe they've heard the totality of the testimony.
Whether or not somebody left a dog behind is not really an issue for this commission to decide.
It goes through to the termination of Kim Kaplan.
I'll permit a question.
You testified in reference to certain dogs being left by Ms. Kaplan. And in fact, those dogs were emaciated, correct?
That's my understanding, yes.
And as a result, they had basically starved to death, to almost the point.
Objection, Your Honor, he's testifying, he's leading.
Well, it's a question.
Objection,
Right on
leading.
meeting, and I'll withdraw it based on the.
Okay. Restate the question in a non-leading fashion.
Were you advised that the dogs were almost dead when they were found?
I was advised that the dogs were left in an extremely poor state without food or water, and that Melody Long had to go over there and have them put down. And she felt that if she didn't go and put the dogs down and take care of it, that Kim Kaplan would fire her.
Now, that certainly is nothing that appears in Ms. Kaplan's report, but it was something you were aware of.
That's correct.
That's good.
Mr. Pitaro, do you have any questions?
No, Your Honor.
Cross-examination?
Government approach?
Yes.
I asked our witness to look at Commission Exhibit 10069 and 071.
See, I see this, but I can barely read what it says. I don't. Okay.
How bad is your eyesight, Your Honor?
It's not bad. If I popped out my contact, then I could see close up a lot better, so.
So I'm just a little surprised that.
That's the
You
first
think-
time I've seen it.
Yeah, so this is fine to where the court is your testimony, correct? To
It's
the
not-
courthouse, to the courthouse.
Fine to where in court, on the bench, or
No.
under a robe. Objection.
Is this
Restate the question.
acceptable under the Nevada Judicial Code to wear to the courthouse? So court staff and litigants and other people who are in the back rooms see this.
Objection to litigants. There's been no testimony that any litigants ever saw this way.
I'm
None.
asking if,
He's posing a hypothetical question.
All right.
I'll allow him to ask the question.
this is okay.
It's not something that I would wear. Like I said, this is the very first time that I have seen it. But I don't know if you've been to the secured parking lot. As judges, we park, we walk across the street, we go into this garage bay, or, where deliveries are coming. We go up this ratty staircase and through the back hallway, up an elevator into our chambers. So, do I think that would be appropriate to wear on the bench? No. Do I find it offensive if it's worn from the parking lot into judicial chambers where somebody then puts on a robe? No. But also, if you were to stand there and look at the other attire that many individuals wear, flip-flops, ripped jeans, dirty sweats, ripped t-shirts, I don't believe we have a code put out that as to what is appropriate attire for judges to wear. Maybe
So
we
it's
should
not,
have one.
it's not beneath the dignity of the judicial office for a judge to wear this at a courthouse outside the courtroom, is your testimony, correct?
From a secure parking lot to the back house of the courthouse and into chambers.
And you don't know whether or not she, when she wasn't on the bench, would go down a front stairway, do you?
I don't know that.
Okay. So you're just assuming based on this that she went directly from a parking garage, didn't see anybody, went into chambers and put on a robe, isn't that true?
That's typically what happens when we as judges arrive to go to court and then when we leave.
So when she's not at the courthouse and she's just in public, she goes to the grocery store and people go, oh, there's Judge Tobiasson, and she's wearing her cupcakes, there's no problem with that either, is there?
I don't believe what a judge wears on their personal time outside of a courthouse should be taken into consideration.
So the judicial code doesn't apply to judge's conduct outside the courthouse, is your testimony?
Objection to the form of the question. There's no context.
You can wear inappropriate clothing outside the courthouse, is your
Does that
testimony?
mean when you go to bed, if you wear an inappropriate shirt, that should be a judicial complaint? Objection to the form of the question.
Let's restate the question, Mr. Adams.
The question is, can a judge wear a sweater that says "eat shirt and die" in public outside the courthouse?
Again, it's, in my opinion, it's perception. And what one person perceives as inappropriate may not be perceived as inappropriate by someone else.
And
It's
how
not
do you
something-
perceive that if you saw her in the grocery store wearing an "eat shit and die" sweater?
I probably wouldn't pay any attention to it whatsoever.
All right, that's all the questions I have. Thank you.
Redirect, Mr. Terry.
Follow-up. Do you believe that Judge Tobiasson poses a substantial threat of serious harm to the public or the administration?
Objection outside the scope of cross.
No, it's not.
I did not ask anything about posing a threat. I asked only about a sweater. It's outside scope.
Every ingredient of this investigation, every ingredient of what you've heard, from swearing to this shirt, is part of what you're going to have to take into consideration. You can tell that by the way that the special prosecutors are asking the questions.
Alternate questions, Mr. Terry.
Thank you. You believe, and I'll ask a duplicative question, that either Judge Chelini or Judge Tobiasson pose a substantial threat of serious harm to the public or to the administration of justice?
Absolutely not. They are both very hardworking judges. They take their jobs very seriously. They are not, in my opinion, a threat to anyone or to the administration of justice.
He's going to testify, and this would be outside the scope, so I'll withdraw the question.
Okay. Do
Another
you have any other questions? Mr. Pitaro, do you have any other questions?
Just follow up with Mr. Terry's question. You are aware, Judge Baucum, that Judge Chelini has been rated the highest retention rate in Las Vegas Justice Court.
Yes, we're all very proud of her.
And her rating is higher than all of the district court judges downtown.
That's my understanding. Yes.
And the Court of Appeals judges and the Supreme Court judges.
I don't recall what their ratings were, but Judge Chelini was definitely the highest at our bench. But well deserved.
I don't know.
Recross.
So the rating included the opinion of Ms. Chelini of 79 people, is all correct?
I don't know what the number was, but that's approximately the number that respond to these judicial polls.
So for example, Tierra Jones had 190 different opinions. That would be a lot less for Ms. Chelini, you can agree?
Yeah, I don't know what Judge Jones had, but if that's what you're telling me, I believe you.
Those are all the questions I have.
Just a quick follow-up question before I let you step down. At what point in time did you learn of the existence of this particular investigation?
It was sometime after I came back from Europe. And I don't recall when Mr. Wisnowski called me for an interview. I think I interviewed with him later in August. I don't know what the exact date was, because I was getting ready to take my daughter off to get her settled at college at George Washington University. So I don't remember if it was before I left to take her August 17th to college, or if it was after I came back. I'm not sure of those dates.
So until you were contacted by the private investigator, you were not aware that there was any investigation of this sort of allegations pending against Judge Chelini and or Judge Tobiasson?
Not exactly, no. I mean, There were some rumblings that there were going to be something filed, but I didn't have any firsthand knowledge of it, no.
So you were aware of rumors to the effect that there would be some complaint against these two judges, but you weren't aware of the formal existence of an investigation. So you returned from your European vacation on July 2nd, and then came into work on July 3rd, and on that date there were two people that were terminated.
That's correct.
July 4th, of course, is a judicial holiday. There was no court on that date. So were you aware of the fact that Mr. Denson was scheduled to meet with the investigator in connection with the investigation of this body on the next business day following the date on which you terminated Mr. Denson?
No, I wasn't. And actually, now that you say this, Mr. Wisnansky did ask me a very similar question to that. And no, I wasn't aware that anybody had been interviewed or that Dave or Elizabeth were to be interviewed. And I believe I asked him that question, although I don't have, a copy of my transcript. But how would I know when he would have scheduled interviews with anybody? I hadn't spoken to any of those people since they were terminated from the court.
An outside observer might find the timing of that termination very unusual. You would say that the timing of that was completely a coincidence.
It was absolutely a coincidence because I had expected when I came back from vacation that both of those individuals would have already been terminated because I had directed Grizel Hernandez and Melanie Long, especially after Dave Benson had called her ignorant, that was absolutely not acceptable to have somebody calling you ignorant.
So
whether it's a superior or a subordinate employee, nobody should be referred to as ignorant.
So you returned from your vacation with the intention to terminate those two individuals without any knowledge of the pendency of this judicial discipline investigation?
Absolutely, and I wanted it done before Melanie Long was going out on FMLA, which I was advised that same day. She was going out that Monday after the 4th of July holiday and would be out with knee replacement surgery. So we didn't know if she'd be back in October, November, December. It was just going to depend, and I didn't want this continued behavior to continue to escalate where Grizel Hernandez or others were being treated in this fashion.
Okay. Did any other commission members have a question? Mr. Armstrong is recognized.
I have one question. What materials were submitted to the judges when Kim Campbell was decided to be terminated? Was it just the OOD summary of findings, or was it actual documentary evidence that reports, summaries, interview notes? What exactly did the judges review in making that determination ultimately to agree to terminate Kim Campbell?
The summary, the same summary that's been given to
That was all that was given to them?
Yes, sir.
Any other questions from commission members? Commissioner Armstrong is recognized.
I have two small questions. One is Melanie Long an employee of the court or is she an employee of the county?
Well, we're all employees of the county, but she's employed.
Judges disagree on that point, right? But I guess I'm wondering, is she under the court or is she in the?
She's under the court. She works for Las Vegas Justice Court, but under Clark County.
Right. There's been in the exhibits an organizational chart of the Clark County Justice Court. We've looked at it, referred to it occasionally. Are you familiar with that?
Yes.
What are the origins of that? Do you know?
I believe that whole thing was put together somewhere by Clark County, body.
Do you know if the judges voted to ratify that as the official organization of the court in some fashion, or has it just been maybe adopted or used as kind of the de facto organizational chart?
I think that's just the chart that we all have been seeing, and that's how it is. I don't think we ever adopted anything, not to my knowledge.
So compliance to that wouldn't be mandated by some kind of court rule or judge's order saying this is it, this is the chain of command, this is just something that you guys have all agreed to participate in by kind of just implied agreement?
I don't know if it's in court rule or not. I'm just being totally honest.
Okay, great. Thank you.
Any other commissioners have any questions? Okay, did the,
If I may, just as a follow-up, the only documentation that you showed the judges was the exhibit or the ODD report.
Yes, there had been a discussion about what I was advised by county HR, but the exhibit that you all have is what the judges made their determination for her termination based from.
I know, yeah, but the issues, other things were stated orally, they just weren't in writing.
That's correct.
Is that correct?
That's correct.
So you had made some oral representations and you submitted to the judges for their review the report from Office of Diversity.
Correct.
That's all.
any other questions from any of the parties? Can the witness be excused?
Yes.
Not about yet.
Okay, you're free to step down. Thank you so much.
Thank you. Do I need to hang around or am I free to
I think
go?
you're free to go. Thank you so much.
Thank you.
Next witness on the Respondents Council. Want to check the time? Can we check the time? Ms. Clerk?
Prosecuting officers have 41 minutes remaining. Respondents have 1 hour, 21 minutes remaining.
Thank you.
Okay, next witness.
Melanie Long.
Melanie Long, if someone could repeat her from the hall, of course.